Mr. Vander Slice, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine.
What happens when a repeat offender gets caught passed out drunk behind the wheel? Again, today's case is about to get intense. We've got Mr. Vander Slice facing his second DWI charge. But wait until you hear what the prosecution reveals about his actual history. The judge, he's not playing games. This defendant is about to learn that second chances come with serious conditions, and one wrong move could land him in a lockdown rehab facility for months. The evidence? 2 bottles of Crown Royal and a refusal to cooperate. The stakes? Up to a year in jail and $4,000 in fines. But here's where it gets wild. The judge is about to drop some of the strictest bond conditions we've ever seen. Buckle up, because this courtroom showdown is about to get real.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. I'll use consent note. 2024, officers were dispatched to a Circle K gas station where they were advised by employees that a white GMC Sierra was in the parking lot. They observed the car was partially in a stall. The driver and one occupant were passed out behind the wheel. The car was running, then it hit a split on the accelerator, but the vehicle was unparked. Officers involved the driver, who was extremely slow and lethargic. He had slurred speech, watery eyes, strong odor of alcohol on his body. He had to be guided back to the patrol vehicle.
Say that again?
He had unsteady gait.
Okay.
He had to be guided back to the patrol vehicle.
Hold up. Let's break this down. The defendant wasn't just drunk. He was passed out behind the wheel with the car running, and he had to be guided back to the patrol vehicle? That's not just intoxicated. That's completely incapacitated. This is exactly the nightmare scenario that DWI laws are designed to prevent. We're talking about someone who could have easily shifted into drive and caused a catastrophic accident. The fact that employees had to call this means multiple people witnessed this dangerous situation. And notice how the prosecutor has to repeat that detail about being guided. Even the judge couldn't believe what he was hearing. This is already painting a picture of someone who was far beyond the legal limit. What would you have done if you found someone like this in a parking lot?
Officers searched the car and found 2 bottles of Crown Royal apple whiskey. One was empty, one had a little bit of it left. The defendant stated, "I'm not going to do anything to incriminate myself," when he was asked to.
Ladies and gentlemen, keep it down in court, please.
I can't hear a thing. Say that again?
When officers asked him to perform the standard field sobriety tests, the defendant responded, "I'm not going to do anything to incriminate myself," and refused to do the tests.
Okay, this is crucial. 2 bottles of Crown Royal. One empty, one almost gone. That's not social drinking. That's binge drinking to the point of blackout. But here's where it gets legally interesting. He refused a field sobriety test, citing self-incrimination. Now, while you DO have the right to refuse these tests, it's often seen as consciousness of guilt in court. Plus, in most states, refusing these tests triggers automatic consequences like license suspension. The irony? By refusing to incriminate himself, he's actually making things worse. The physical evidence, passed out, bottles in the car, having to be guided to the police vehicle, that's already damning enough. His refusal just adds another layer to the prosecution's case. Smart move, or did he just dig himself deeper?
The DIC was read, search warrant was executed, and blood was drawn. The first DWI is in 2017 for Panola.
And then how many DWIs can you...
There was also a dismissed DWI in 2009 in Dallas.
So that's
It's his 3rd DWI arrest.
There's one conviction and it's a reckless driving. It's in the computer wrong. I have the judgment.
Wait, what? The plot thickens. This isn't his second offense. This is his 3rd DWI arrest. We got 2009 dismissed, 2017 convicted as reckless driving, and now this. The prosecution just revealed a pattern spanning over 15 years. And notice how they had to correct the computer records? That 2017 conviction that was supposedly just reckless driving. The prosecutor has the actual judgment showing it was a DWI. This changes everything. Repeat offenders face exponentially harsher penalties, and judges have way less sympathy. The defendant's attorney is probably sweating bullets right now, because this history shows someone who hasn't learned their lesson despite multiple encounters with the legal system. The judge is about to come down hard. Honestly, can you blame him?
So,
Mr. Vander Slice, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
I'm going to tell you now, when you have alcohol in the car, it's a minimum of 5 days in jail to any sentence that you get.
Yes, sir.
Do you understand, sir?
Yes, sir.
I'm ordering you now not to drive any vehicle that's not equipped with an ignition interlock. If I find that you're consuming alcohol, dope, you drive without with either a license, without a license, or without using your interlock, I will put you in jail. You will not get any more PR bonds.
The judge just laid down the law. Mandatory ignition interlock device. That a breathalyzer built into your car that you have to blow into before it starts. And he's guaranteeing minimum 5 days jail time regardless of any plea deal. But here's what's really happening. The judge is setting a legal trap. Any violation of these conditions means instant jail, no more personal recognizance bonds. That means if he screws up even once, he's sitting in jail until trial, which could be months. The judge is essentially putting him on a zero-tolerance policy. 1 drink, 1 drive without the interlock, and it's over. This is what accountability looks like in the legal system. The question is, will this finally be the wake-up call, or is he heading straight back to jail?
If you show me that you have a problem with alcohol and dope, I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a lockdown rehab facility. Do you understand?
Yes, sir.
If you have demons, you better address it, because if you don't, I'm going to do it for you if it becomes a problem, and I promise you, you're not going to like the way that I do it.
Yes, sir.
This is the most brutal judicial warning I've heard in the courtroom. The judge just threatened lockdown rehab. That's not outpatient treatment where you go home at night. That's involuntary confinement in a rehabilitation facility for 180 days. 6 months of your life, locked away, forced into treatment. And notice the language. If you have demons, you better address it, because if you don't, I'm going to do it for you. This judge is basically saying get help or I'll make you get help. The contempt of court charge he's threatening carries serious weight. It's the judge's nuclear option. This isn't just about punishment anymore. It's about forced intervention. The judge sees an addict who's endangering lives, and he's ready to use every legal tool at his disposal. The real question is this tough love or judicial overreach?
and Judge, I know you have a jury right now, but there is a backstory. Yeah, I know, I understand.
So all I know now is that no drugs, no alcohol. I'm going to randomly test you. You are not allowed to drive without a guardian interlock. You have a lawyer. Mr. Ray will take care of the case for you. You must stay in touch with him. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Yes, sir.
No more PR bonds.
Yes, sir.
All right. I'll have you go to Victoria, sign a reset. After that, eventually you'll get with Anna for your bond conditions. And after that, you'll be free to go, sir.
Let's recap this insane case. Mr. Vander Slice, caught passed out drunk behind the wheel with 2 bottles of Crown Royal, facing his 3rd DWI arrest in 15 years. The evidence? Overwhelming. The judge's response? Unprecedented. We're talking mandatory ignition interlock, random drug and alcohol testing, 0 tolerance for any violation, and the threat of 180 days in lockdown rehab if he slips up even once. This judge made it crystal clear. 1 wrong move, and it's straight to jail with no more chances. The minimum 5-day jail sentence is already guaranteed. This case shows exactly how the justice system escalates penalties for repeat offenders who refuse to change. The real tragedy? This could have been avoided if he'd gotten help after the first arrest in 2009. Now he's facing the full force of the law. If this case shocked you as much as it shocked us, smash that like button right now. Drop a comment below. Do you think the judge was too harsh or totally justified? And if you want to see more real courtroom drama like this, hit that subscribe button and ring the notification bell so you never miss our next breakdown. Share this with someone who needs to see the real consequences of drunk driving. Until next time, stay safe and stay legal.